Good afternoon, everyone. Allison Scoberg here. We are happy to bring a new topic to you guys today. We are going to be talking today about advanced issues as it relates to special needs trust planning for what we know as a disabled adult child or childhood disability benefits, RSDI, also called DAC. We're going to take a deep dive into some of the complex issues. So today we're doing things a little bit differently. So if you've attended before, we're glad that you're back. Again, we've never done this topic today. We're happy to be here with Jen Coulter, Townsend Allala, Coulter, and Kludt. I got it. So I was trying not to mess that name up. A law firm that specializes in families with disabilities. So we're going to take a deep dive into all of these issues. So a lot of questions, a lot of advanced questions were sent in ahead of time for this meeting. So we're going to address those questions. So typically we take questions throughout the presentation. You can put your questions in the chat box throughout the presentation, but we're going to save those questions to the end because we're going to answer a lot of those questions during the time that we have today. So from a housekeeping perspective, we are in webinar mode today, which means that we can't see you or hear you, but we know you're there and we're glad that you're here. This is being recorded, so everybody that has registered for this is going to get a copy of the slides and a link to the recording following this presentation. So thank you all for being here. Consolidated Planning Group is a holistic special needs financial planning firm. We're nationally certified as Social Security advisors, members of the Special Needs Planning Academy. I know a lot of our attendees today have worked with us in the past, and we certainly appreciate that. We help people plan for the future of a loved one with a disability. We help make sure that they have money in the right buckets to preserve eligibility for state and federally funded programs, namely Medicaid and SSI. We help people understand how much money they're going to need in their special needs trust to fund the future care for their loved one. We help open ABLE accounts and a myriad of other planning things. Our situation is specialized when it comes to caring for a loved one with a disability. And as a parent, we're going to be spending 25 to 35 years in retirement. We have a loved one with a disability, and a lot of families have more than one child with a disability. It's like a second or third or fourth bucket of retirement when we have someone that we care for that's going to have care needs, 20 to 30 years after we're gone. So we're certainly here to help you with that. So having said that, Jen, it's certainly our pleasure to be here with you today and your advanced knowledge on these issues. I would also like to give a shout out to Family to Family Network and some of the advanced questions that they had sent ahead of time, as well as Beth Ruffin for helping orchestrate and putting all of this together. So Jen, thank you for being here. I'm going to turn things over to you.
Well, thank you guys for having me. I really love to talk to people like y'all who have loved ones with disabilities because you guys are the best informed and you have the best questions. I really was glad to get a lot of these questions in advance. When we start here with our slides, we're going to start with setting ourselves a common vocabulary. It's very easy with these kinds of benefits and programs to use terms casually in ways that aren't always as clear as we need them to be. And one of the things that we know as we go along with these things is sometimes we need to be very clear, because being very clear can make the difference between we did this properly and oops, we messed up. So knowing what we're talking about is always our starting place. So I want to kind of start you with the various cash benefits that are available. There's supplemental security income, SSI, that is available to people who are disabled, who is blind, disabled, or over 65. But for our purposes, for a person who's disabled with modified adjusted gross income, that's MAGI, which is how the SSA determines income for this program, of less than $943 a month, and countable resources of less than $2,000. This is what most people are going to be familiar with when their child with disabilities first gets old enough to receive benefits. There's disabled adult child benefits. These are DAC benefits. I will say that, oh, 10 years or so ago, the Social Security Administration randomly decided they weren't going to call it DAC anymore and started calling it Childhood Disability Benefits, CDB. But you will still hear those two terms used interchangeably, which honestly is kind of a problem because DAC is also something in the Medicaid context. Here, for the sake of convenience for everybody who's known it as DAC forever, we are calling it DAC. DAC is for a person who became disabled before age 22 and whose parents, sometimes it can be a step parent or grandparent, is deceased, retired, or on disability themselves. Social Security Disability Income, SSDI, is going to be for a person who meets the definition of disability, who has a sufficient number of work orders. You can be receiving more than one type of these cash benefits. You could be receiving multiple kinds. So you may get SSDI and SSI, or DAC and SSI, depending on how much the other entitlement is. So if the SSDI entitlement is small, say you have a child who was able to work some when they first got out of high school, but their disability became progressively worse, and now they are no longer able to work. They may be able to get SSDI based on their work history, but it may not be large enough to bump them off of SSI. So it's really important to know the kind of benefits. Okay, let's move on to the kind of medical benefits. There's two.
Jen, I just wanted to mention that there's a few cases a year that we see that they're actually getting some SSI, some SSDI under their own record, and some DAC benefits. It's not that often, but we absolutely do see that. So I imagine there's probably somebody on here that may have a kid that's in that category. So I just wanted to mention that.
It absolutely happens. And you may not always know because the part of the way that I will start with somebody to try to figure out what kind of benefits they're getting is say, how much income is the person receiving? If they're getting 943, well, then I'm pretty much going to know that we're getting probably some SSI. But if we're getting 950 or 962, we may be getting SSI and SSDI or DAC. We may be getting one of those other kinds of benefits as well. So it's not even knowing the exact dollar amount you're getting is necessarily the end point. It may just be a starting place for how we get to figuring out what's going on. When we look at the medical benefits, there's two basic kinds. There's Medicare, that's going to be available to people getting SSDI or RSDI, which is retirement survivors and dependents income. So that's going to catch those other people. And there's Medicaid. Now, this is where a lot of problems come in. Medicaid is not one thing, right? Medicaid is a series of federally mandated programs. They are all administered on a state-by-state basis. One of the things that that means is you can't think of Medicaid as one thing. I have Medicaid, because it's not one thing. In Texas, there are 109 different Medicaid programs. The last time anybody I know counted, I don't sit around and count it on a regular basis, but not even all of them operate in every part of the state. So I'm out here in El Paso County, and we have a program called PACE, the Program of All-Inclusive Care for the Elderly. That program only operates in 3 counties in the state of Texas. So even within the state, it's not always 100% easy to determine what kind of benefits there are. And each of those various programs is going to have slightly different requirements or slightly different benefits, or both. Not every Medicaid program, for example, is going to be resource tested. CHIP is a Medicaid program, but it is not resource tested, only income tested. Breast and cervical cancer Medicaid are also not resource tested. Not all of the programs are going to have the same income or resource tests depending on the program and on marital status. So let's look at some of the common types that you guys might see. There's going to be the regular Medicaid that comes with SSI benefits. This is what most people, when they think of Medicaid, this is what they think of. Medicaid that you use as health insurance. There's going to be the waiver programs like class MDCP, which is medically dependent children's program, and Star Plus Plus. There's a bunch of the waiver programs. These can provide in-home care in addition to providing insurance, including supplemental to Medicare. There's the Medicare savings programs. These pick up, depending on which Medicare savings program you fall into, they can pick up the Part B premiums for Medicare. They can pick up the co-payments and deductibles that Medicare doesn't otherwise cover. So when we start talking about Medicaid, it's important to know there's a whole huge range of things happening. I also want to just give us a little bit of a framework to talk about special needs trusts, because there are various types, and the various types make a huge difference in what we can and cannot do for them. So we've got third-party settled special needs trusts, self-settled special needs trusts. You'll sometimes hear those called first-party or D4A trusts. We have pooled trusts. These are through people like the Arc of Texas. I think every state's got an Arc of that holds a master pool trust. There are sole benefit trusts, which are a super handy device. I just real quickly want to tell you what each of those are. So third-party trusts are going to be established by someone other than the person with the disabilities. So most of the time, this is the parents doing planning for their kids. The parents is created. It's funded with money by belonging to someone other than the person with disability. So mom and dad set up the third-party special needs trust. They fund it with their own money. The trustee should not be the person with the disabilities. So maybe they name each other first, and then one of their kids without disabilities, one of their family members, maybe they name a corporate trustee, because naming a family member is just a recipe for drama to happen. These do not require a Medicaid payback provision in them, but I will tell you this, if there's a Medicaid payback provision in them, the terms of the trust will control and the state will be paid back. Do not put a Medicaid payback provision in a third-party settled special needs trust. Okay, a self-settled special needs trust, we sometimes call it a D4A trust because it's allowed under 42 USC section 1396P D4A. These are created by the person, a parent, grandparent, guardian, or the court. They are funded with funds belonging to the person with disabilities. They must be created before the person turns 65. The person must have a disability. It must be for the sole benefit of the person with the disability. So if you have multiple children with disabilities, you can't just have one self-settled special needs trust for all of them. Each of them, if they're going to have self-settled special needs trust, must have their own. This requires a Medicaid payback provision. Okay, pooled trusts, these are going to be managed by a nonprofit. This is something like the Arc of Texas. You don't have to use the Arc of Texas. We usually do when we do them, but you can use anybody you want. You should, of course, be careful with them, as with any fiduciary. So they're established and operated by a nonprofit. It's usually funded with the funds belonging to a person with the disabilities. So this is the same that you might create a self-settled special needs trust, but you go, I don't have a good fiduciary and we don't have enough money for a corporate fiduciary to want to do it, or we don't have a good corporate fiduciary we trust right now. You might use the Arc of Texas or some other master pool trust. But it doesn't have to be with the funds belonging to the person. Those pooled trusts will also have third-party pooled trusts. The idea is that they will take all of the money and pool it all for investment purposes, but keep separate sub-accounts to keep track of whose money is whose. If it's self-settled, I hate to say self-settled, but if it's funded with money belonging to the person with disabilities, then it must require that the funds either be paid back to the state or to be held with the nonprofit to defray the costs of administration. That can make them a lower cost option than a corporate fiduciary.
Jen, I just wanted to mention on the corporate fiduciaries, because we get
Mhm.
questions on that all the time from families that say, listen, there is nobody else after me to be the trustee, but these families don't want the pool trust. They have their own special needs trust. And I just wanted to mention that there are several banks, Cadence Bank, Bank of Texas,
Mhm.
Frost Bank, are
Mhm.
some that come to my mind that have whole divisions for special
Yeah.
needs and trust administration. So there are corporate trustees. If you have your own third party special needs trust or special needs trust that you need a corporate trustee in the future for, those may be some that you will look to if you know, should you not be interested in a pooled trust.
And those are good ones. Cadence, Bank of Texas, and Frost Bank. They, like she says, they have a whole department set up for just doing that. They routinely attend the special needs trust conferences. They know their stuff. We talk to them on the regular, and they are very knowledgeable.
I think
Um,
they're all great. So
yeah,
yes,
yeah,
just know that
sure,
there's options out there,
yeah.
and leaning on a bank that has the special needs, you know, division to handle these things. They are good and nuanced at this. And some people may actually have family members that they trust, but there's so much money in the trust, it's kind of a big job for them, and maybe a corporate trustee is a better idea. So I just wanted to put that out there.
Well, one of the problems with using family member trustees can be that one, it can create drama in the family. So if I have to go, I have a brother and a sister, and I love my brother and I love my sister. They're wonderful people. But if I had to go to my sister to ask for money every time I needed to do something, that would cause us some strain in our relationship. I am a grown up, responsible, independent human being. And if I talk to my sister about what I'm spending my money on, it still causes a little strain in our relationship. So having that extra dynamic where one of the kids has power over money belonging to it for the benefit of the other kid, it can be a problem. Some of the corporate trustees also are going to have, they can be really excellent, but they can have higher thresholds for taking on those trusts. So if you've got a little bit of a smaller trust, that can be an issue. Um, so it's a lot to think about and balance out when you're doing this. Sole benefit trusts. I know that sounds like a self-settled special needs trust because I said it must be for the sole benefit of the beneficiary, but this is actually a really special kind of. This is a trust where our grantor, the person who's creating the trust, themselves may need benefits. Uh, they are going to use their own money to fund it, and they want to do it for the benefit either of their own child who is disabled or for any other person who's under 65 who is disabled. So, for example, mom has a child who is disabled. Mom needs long term care in a nursing facility. Mom has several $100,000 sitting in the bank and her home. She doesn't just want to spend those several $100,000 down and pay the facility until she's broke and then she can apply for Medicaid. Instead, she might create this kind of sole benefit trust for the benefit of her child with disabilities, put all the money into that sole benefit trust, and then voila, become eligible for benefits immediately without having to do that big spend down while she can protect her child with disabilities. Why can't she just do a plain old normal third party settled special needs trust? Because that would trigger a penalty period for up to 5 years from the benefits. So, big, huge doe eyes there because that is a scary outcome that we don't normally anticipate. So, this sole benefit trust that prevents that potential penalty period. Part of what makes this distinct from a third party trust, generally, it must be for the sole benefit of a single beneficiary. So if you've got two kids with disabilities, you're going to have two of them. And it must make at least actuarially sound distributions. So it must require distributions in a way that a regular third party trust shouldn't. Okay, so let's talk a little bit about income counting because that's going to be where a lot of the issues with how do we pay out of these trusts for DAC beneficiaries, for SSI beneficiaries, that's going to be where a lot of this issues come from. For programs like most Medicaid programs and for SSI, uh, part of the discrimination for eligibility is going to be an income. The income rules vary depending on the program that they're getting. So SSI income, SSI uses MAGI, as does Medicare savings programs, but not other programs like the waiver programs, nursing home Medicaid, Medicaid for programs covering placements in intermediate care facilities. So the SSI income limit is $943. They're going to count most unearned income. So for example, let's say that your child is also receiving DAC. They're going to count that DAC income, but they're going to disregard the first $20. That's why I said we might look at a person who's getting $962 and say, oh, look, they're disregarding the first $20. We're still getting the SSI here. For income, they're going to count earned income. So if your person is able to work some, they're going to count it. They're going to disregard the first $65, and then they're going to count $1 for every $2 that are earned. That is the nutshell version of it, but let me tell you, those calculations are complicated. And most importantly, it's going to count in-kind support and maintenance. So let's talk about what that is. ISM is generally going to be food and shelter paid by another person for the person with disabilities. Before you start posting in the message board that the rules changed on September 1 and food no longer counts, that is sort of true. We're still trying to figure out exactly how it does and does not count. But the answer is food counts in fewer contexts now and can be paid for in more contexts, but there are still contexts in which someone else paying for food will still count. And shelter expenses, that's going to be rent. That's going to be property taxes. That's going to be the utilities, the electric, water, gas, sewage. All of those things are going to be countable as in-kind support and maintenance if someone else is paying them on behalf of the person with disabilities who's receiving one of the programs that counts it. For SSI purposes, they're going to cap it at 1/3. So if you're paying out like $2,000 a month for those expenses, they're going to cap it at 1/3 of the value of the maximum amount, which is about $314 a month. So sometimes, even where it will cause a reduction in benefits, it might be worthwhile to have a trust paying out for those things directly. Even though it will cause a reduction in benefits, if they're receiving more than that $314 a month, then they'll still get that $1 in SSI, and all you need for Medicaid is $1 in SSI. So you can go forward from there and do some calculations that may say it makes sense for a trust or for a parent to be paying out for food and shelter expenses.
Jen, I want to talk about that because you said something that's very important because we hear a myth all the time, right? This myth of, I heard that a special needs trust cannot pay for food and shelter, and that's simply not true. It can, but there could be a 1/3 reduction to SSI. So that's one thing. But the other thing that I want you to address before we move on is that some of these corporate trustees have wording like if they're the corporate trustee that they absolutely will not ever pay for food and shelter out of the special needs trust, whereas some of these people that maybe they've moved over to DAC status or childhood disability benefits, it may not matter as much. So can you address that?
Well, the first thing you want to do is make sure you're reading your trust instrument when you're setting it up, because if a trust instrument just outright prohibits those distributions, then the trustee simply cannot pay for them. And there's no need ever for any trust to ever explicitly say that the trustee cannot pay for food and shelter expenses. It's just, even if you're getting SSI, it's not a good idea to have that kind of language in there. It really restricts what the fiduciary can and cannot do. So make sure you're reading your trust documents. But yes, if the trust is properly drafted and you've got a trustee who's still saying, we won't pay for it, that's just a rule of ours, we will not pay for food and shelter expenses, that should be a red flag. So when you are looking at picking out corporate fiduciaries, make sure you're talking to them about this issue in particular, because we don't want to pick somebody who's saying we won't pay for something that we could pay for. We try to give the trustee the ability to pay for anything that is in the best interest of our beneficiary. And even if our beneficiary is an SSI recipient, where paying for food and shelter may in fact cause a reduction in benefits, that may still be in their best interest. To say you have to, from your $943 a month, pay for all of your food and shelter expenses, well, we're basically telling you, you have to live at a very low quality of life. You have to live in a very cheap place to live. You have to live in relative poverty, even if there's a lot of money sitting in your trust. And that's not something we really want to do for people. We don't want to tell them you must live in poverty. Part of the reason we're giving or doing special needs trusts, part of the reason that ABLE accounts got established in the first place was we want to break the cycle of poverty that most people with disabilities end up living in. So I think it's really important to know that that is not true. It is a huge myth. There's even a self-settled special needs trust should not have express language prohibiting the payment of food and shelter expenses. For waiver programs, let me just tell you this. They do not count ISM. They have a $2,829 a month income limit, and if that income limit is exceeded, it can be fixed with a qualified income trust. So sometimes we'll get people who are getting SSI, and then one of the parents passes away, and now they're getting DAC income, but they're also getting a joint and survivors annuity from TRS or something else like that. And that combined income bumps them way high over the income thresholds. But if they're getting waiver program benefits, we can fix those problems with a qualified income trust. And they aren't going to count ISM for those special needs trusts. I'm sorry, for the waiver programs. So let's talk about how we make distributions from an SNT. They could be made for any purpose that the trust permits. That's what we were talking about earlier. So if your trust says, no, you can only make them, you can't make them for food and shelter expenses, then you can't make them for food and shelter expenses. The distributions can be income to the individual depending on how the distributions are made. And let me pause here to say, income for benefits purposes is not the same thing as income for IRS purposes. So if you're looking at it and you're saying, well, the IRS says that if the trust pays for the phone bill and the car insurance, that's income. That is true. That's income for IRS purposes for the beneficiary, but it is not income for Social Security purposes or for SSI purposes, for Medicaid purposes. If the trust pays the phone bill and the internet bill and the car insurance bill directly, it would be, though, if they paid cash to the beneficiary, and then the beneficiary uses those funds to pay those expenses. So we've got some best distribution practices here. Obviously, to the extent possible and reasonable, we don't want our trustees making distributions that could cause disqualification. Occasionally, though, we do want them to make distributions that cause disqualification. It's very much going to be fact dependent, and so we want to give our trustees a lot of discretion to do whatever is in the best interest of the person. We like to make distributions directly to providers. We make them to ABLE accounts. If you guys don't know what ABLE accounts are, let me pause and take a moment because I don't think I talk about it anywhere else. ABLE accounts are the Achieving a Better Life Experience Act. They are an account that belongs to the person with disabilities. They are exempt, though, for the first $100,000 in them. They can be funded with the annual gift tax exclusion amount each year. This year, that's $18,000. So you can put $18,000 a year in it from any source. That money then is the person's money. It's a resource that belongs to the person. So if the person uses it to pay in-kind support and maintenance costs, then there is no 1/3 reduction. So sometimes for people who can qualify for it, we may take money from the third-party settled special needs trust, put it into the ABLE account, have the ABLE account then pay the food and shelter expenses, no reduction in cost or in benefits as a result. ABLE accounts right now, you must have become disabled before age 26, but in 2026, that age is going up to you must have become disabled before age 46, which is super exciting. And now we're going to talk about the questions that you guys had for me, which, let me tell you, were all really good questions. Okay.
Okay, so our first question, can the third-party special needs trust pay for food and basic shelter? ISM expenses, food, rent, mortgage, required insurance, property taxes, electric, gas, water, sewer, etc., without impacting or counting as income for waiver Medicaid or DAC Medicaid.
So let's take a look at this. And the answer is, at least for the waiver programs, generally yes, right? Because what we said was waiver programs don't count income support and maintenance. If you're not getting one of the waiver programs and you're instead getting just DAC Medicaid, then it will still be counted as in-kind support and maintenance to the extent that we said that it could be counted as in-kind support and maintenance. But it won't count for the cash benefits themselves, because the cash benefits themselves are not dependent on those kinds of income, only on disability, the age of the disability, and the status of the person on whose work history you are drawing. So that's kind of three separate kind of issues: waiver programs, DAC Medicaid, and DAC or CDB benefits that you get through the Social Security Administration.
Now, on your previous slide, you had the TrueLink card, and I just wanted to mention on October 23rd at noon, we have a webinar about the TrueLink card. So if you're hearing that for the first time, you'll want to attend or go back and see it on the YouTube channel later. But that'll be the first time we've done a webinar for the TrueLink card, but it is definitely coming up.
Excellent. That's a really good thing. The TrueLink card can be really helpful in managing these kinds of trusts while giving the person with disabilities some freedoms that we would like them to have, to be as independent as possible. We want the trustees to be paying these payments properly, and properly means, again, the trust pays the providers directly. They don't give cash to the beneficiary. In my office, the words cash and gift are four-letter words, and I ask people not to use them. Okay, there's a few times where you can use them, like any four-letter word, but you've got to know the time and place appropriateness for that.
To do it correctly. Okay, if it is true that third-party special needs trusts can pay for food and basic shelter expenses without impacting DAC and waiver Medicaid, do you draft the third-party special needs trust to make it clear to the trustee that this is allowed? What does that language look like?
Well, I generally prefer a less is more approach in my language. So my trust itself is basically going to say that the trustee has the absolute discretion to make any distributions that the trustee believes are in the best interest of the beneficiary. I pretty much want to be done right there, because the more restrictions I'm giving, the more language I'm putting in, the more likely it is that my trust is going to get flagged by the SSA or by Health and Human Services, depending on which agency you're having to report to. And if anybody has ever dealt with the SSA not loving a trust that they've got, it's a hassle, a huge hassle. So I try to be as general as possible. But what we might want to do, if we come down to the next, oh, look, 2 slides down here. What we might want to do, though, is include language to the trustee in a letter to the trustee of direction. And that letter to the trustee can say, essentially, dear trustee, it is my intention with this trust to fund the beneficiary's lifestyle as liberally as is possible, given the governmental benefits programs that they are receiving, even if that means taking a reduction in benefits, even if it means entirely disqualifying them from benefits, if that's what's in their best interest. We want you to do a calculus, but we also want you to know you can be paying for entertainment, food, shelter, educational expenses, trips, hobbies, medical services that aren't otherwise covered by the program. You can give them a long list here. This is what lawyers call precatory language, which means it's not enforceable on the trustee, but trustees really like to have guidance letters that tell them what your intention is. If your intention is, I want all of this money used for the beneficiary, I don't care about remainder beneficiaries, that I want in the trust language itself. But for do make these distributions, I really want to make that language be as broad as possible and then give a letter of instruction.
Who in the trust document is typically given the right to amend a trust for changes in the laws, interpretations of the law, rules, regulations, tax codes, Scrivener errors, potential remainder beneficiaries who were not born at the time of the drafting, etc.
Okay, let's answer the easy part first. We give the trustee, or sometimes the trust protector, depending on how you structured your trust, the ability to amend the administrative non-dispositive provisions. So the things like, oh, the rules have changed and now we need to amend the language to comply with those rules. The SSA does not love our spendthrift provision. We need to update our spendthrift provision. Those kinds of things we give to the trustee or the trust protector. The grantor, the person who establishes the trust, as long as it's not a self-settled special needs trust, should have the ability to amend the remainder beneficiaries. But the truth is, I want my grantor planning for the zombie apocalypse. There's a number of different reasons for that. One of them is I may want people who are not the grantor contributing to this third-party trust. In families where we may have blended families, where there may be divorces, where we may have grandparents who want to benefit the child, they don't love to see language that says for the child, for their benefit for life, but on their death, the grantor gets to decide where it goes, right? If I am the grantor, but my ex might want to contribute to that trust, my ex is not going to be real thrilled with me having the ability to decide where that goes in a way that is amendable. So what we want to do is make sure that we've got those set up, but we also want to plan for the zombie apocalypse just generally. This is something I want everybody thinking about all the time. So the initial establishment of the trust should be creating remainder beneficiaries for as far down as we can think, all the way down to what we call contingent remainder beneficiaries, which is essentially the people who would have taken if I died without a will, but without the need to go to court. So our more distant heirs at law. One of the things that I think this question is trying to get at is, what if I've got the trust set up for the benefit of my child with special needs, child A, but child B, who's one of the remainder beneficiaries, later develops a disability themselves. And now I don't want to give the money outright to B when A dies because whoops. Or what if A later has children and now I've got stuff going to B, but I really want A's stuff to go to A's kids now that A has kids, because our circumstances change. So we want to plan for those things. And if you're talking to a good attorney establishing this kind of trust for you, they're going to ask you those questions. What if A has children later? Do you still want it to go to B? What if B predeceases? Where do you want it to go? But one of the other things that we should be looking at there are contingent trusts. Do I have that here? Yes, okay. In the next slide there, we've got contingent trusts. Contingent trusts can and should be set up in every trust and in your wills. And those contingent trusts basically say, in the event that a beneficiary under this trust or under my will is a person who's disabled and receiving or anticipating the receipt of means-tested governmental benefits, is a person whose resources are deemed to a person who's disabled and receiving or anticipating the receipt of means-tested benefits, is a minor, is in the middle of a divorce proceeding, it's in the middle of a bankruptcy proceeding, is, and this one got added to my list from real world experience, in prison for a period of years, then don't give them the money outright. Let's put the money into a continuing trust for their benefit. So we can set up that as a contingency that says, what if these things happen in the future? And we can plan for what if scenarios. And I really want you guys to be planning for what if scenarios when you're setting these things up.
Sorry, we had a little bit of issue with the slides, and I apologize for that.
Yeah.
One of the things that I think it is important to mention to folks, because people think that they go and visit the attorney and they drop $3,000 to $5,000 and they get their documents set up and they should just set them on the shelf and be done with it. And we give the advice that we think that your documents should be reviewed every 3 to 5 years because best practices change, laws change. Situations changed, as you mentioned, Jen. And it doesn't mean that you have to redo your documents every 3 to 5 years, but it's a really good idea to get them reviewed. Do you agree with that, Jen?
Absolutely. I want to plan for the zombie apocalypse, but I want you looking at it from time to time. We usually tell people pull it out when you're doing your taxes. Just take a look, make sure everything still looks right. Talk to us if there's anything that's changing. If you have, no matter how often you're doing it, every year when you do your taxes, 3 to 5 years, if you have a change in family circumstance, that's always a good time to do it. Take them out, look at them, talk to your attorney again. If you note that there's a change in the law, take them out, talk to your attorney. Your attorney may also be keeping track of changes in the law and may send you a letter that says, hey, just so you know, there's been some changes in the law. But keep an eye on them because, yeah, absolutely. We want to plan for the zombie apocalypse because a lot of people do, in fact, throw them in a drawer and forget about them. But you really should be keeping on top of it. Look at it every couple of years for sure.
So we have about 18 minutes left for today. So we've got the successor trustee as a sibling. Do you want to chat about that?
Yes. So um, this can be a problem because our sibling might also be a remainder beneficiary. That can create some tensions, especially if we've got our sibling may say, yeah, I don't know that you need this distribution. And if I don't give you this distribution, that could come to me when you die, right? So it can create problems. There's a few things that you can do there. One of them is, like we discussed before, you can use that kind of language that says, it is my intention that all of these funds be used, even to the point of exhaustion, for the primary beneficiary. It You may want to waive the fiduciary's duty to balance the interests of the remainder beneficiaries and the primary beneficiary and say, we don't care about them balancing those interests. All of this can be and may be used for the benefit of the person who is the primary beneficiary. But it's also something that you want to think about just as a general rule. Is the sibling someone who will in fact be paying attention to their sibling, their disabled siblings' needs? And if they aren't, then they're probably not a good person to be naming as the trustee.
And we talk about that too for families, and this is not to step on anybody's toes or anything like that, that are planning on naming a sibling as a successor caregiver or a future guardian of the sibling. And we tend to provide the advice to avoid that. We want it to not be an obligatory relationship. We want it to be a loving relationship.
Mhm.
And just as we had hopes and dreams when we were in our 20s and 30s and 40s, whether you were going to get married or have a home or have a marriage or have kids or all of the things that people like to do in their life, your kids have those same hopes and dreams. Your other kids have those same hopes and dreams too. And sometimes being saddled up with the responsibility of caregiver for a sibling can cause issues in their marriage, their job, their finances, you name it. So we always say, think carefully on that. And maybe you have kids with 20-year age differences and your situation's a little bit different. There are the one-off situations, but in general, we like to see that there's enough money in the special needs trust to fund future care for your loved one with a disability, to keep them in home or community-based services to where they have purpose, they have friends, they have community, they have some autonomy, they're not being told what to do by a sibling, that kind of thing. I think it's a better, healthier relationship for most. So our next question here is, can the parent grant or
Sorry,
limit?
before we move on to the next question, let me just real quick.
Sure.
Using trust protectors can also help in that situation. If you think the sibling relationship is going to work out fine, this person is never going to be a problem, they're always going to do what's in their disabled siblings' best interests. Having a trust protector there who can say, well, this is going off the rails, they're refusing to make distributions that are completely reasonable, and having that trust protector have the ability to remove them if they are acting interested, that can be really helpful too.
That's good. Good stuff. Can the parent grantor limit certain powers of a successor trustee, such as certain investment powers?
Absolutely. So when you create a trust, you are creating the law that governs that trust. There are some things that can't be waived, but most things you can decide on. So you can decide to limit the abilities to invest. You can decide to limit any of the powers of the trustee. That is very doable. One of the things though that I do like to consider is, why are you wanting to limit those powers? If you are wanting to limit those powers because you don't trust the person that you're naming to invest wisely, that is kind of a red flag for me that maybe you shouldn't be naming that person as a trustee. Uh, and remember that every trustee, no matter what trust powers they have, has a duty to invest as a reasonably prudent investor would. So under no circumstances is any trustee ever permitted, no matter what kinds of investment powers or other powers they have, are they permitted to, invest in their salad to go uh, restaurant that they want to create from scratch, right? That's not as to put all of the money into it. That's not what a reasonably prudent investor would do. Um, but I think that the larger question there is, if you're really wanting to limit it, I want to find out why.
So we've got this question on the screen. Can a parent grant or mandate a successor trustee to invest only in low cost index funds?
Yes, they certainly can. It's kind of the same thing. You're creating that law that controls the trustee. But again, I want to find out why. Does this trustee have a bad history? Let's remember that trustees do misbehave. Uh, and finding out that a trustee has misbehaved is not always real easy to do. My favorite slash most terrifying story about this is about a guy up in Alaska who was the trustee for an enormous trust, multi-million dollar trust. And over the course of 6 months, he decided that it was going to be very important. The apocalypse was coming. And it was going to be very important to have gold bars and food and an air defense system. So the way that the trustee got found out in this situation was that when you attempt to buy missiles from Russia, the US government gets very interested in your actions. So more than $100 million later in spending, the trustee got caught. So even the trustee did not have the authority to do any of that, but even where that can happen, trustees can't go off the rails. So if you've got concerns about your trustee before you're naming them, I want to be flagging that and saying, maybe we don't think this person is a good person.
And I just want to say, we have a person that was taken advantage of. The parent died while the person was still a minor, and the parent's best friend was the trustee, and basically really took advantage of the trust, and then was later found out when the kid was now an adult, but then the trustee had died. And the bottom line is the money was lost. It was over.
Mhm, mhm.
And so that's why you do want to make, very careful decisions on that. We're not trying to scare anybody, but careful decisions. And also, being a trustee is not for the faint of heart. There's a lot of record keeping, there's a lot of money and financials and duties of a trustee. And for somebody that does not have a business mind or business background or even a finance background, it might be difficult, depending on how much money is in there. Now, if we're talking a tiny trust, then that's a different story than the examples that we're talking about with trusts that have, millions of dollars in them. So from a time perspective, we got about 10 minutes left for today. So we're going to run through some more of these questions. Can a third-party special needs trust purchase and maintain a residence for the beneficiary to live, even with the prudent investor rule?
Generally speaking, yes, but it doesn't hurt to have good language in your trust that includes that ability.
And Jen, I'm a fan of the trust owning that house in the example of the individual with the disability is vulnerable to being taken advantage of. So there's protections in place so the person cannot be hoodooed out of their house, basically.
For a
And
third party trust, I agree. For a self settled trust, I want the trust to purchase the home and then put it in the name of the individual, because those
that's
self
because
settled
there would
trusts.
be a Medicaid payback in that first party. You're exactly right. Got it. Can a third-party special needs trust that owns a residence for the beneficiary to live in be mandated to maintain the resident in good repair without affecting means tested benefits?
Of course, the trust owns that house. It should be maintaining it. That is part of its duty as the trustee. If it doesn't maintain the property, that property deteriorates in value. you are not acting as a prudent investor would. So that maintaining it itself doesn't necessarily cause any change in benefits unless maintaining it also in good repair also includes paying ISM, basically letting the beneficiaries live there rent-free and without paying those food and shelter expenses, in which case you may result in a reduction in benefits, depending on the kind of benefit you're receiving.
And for the sake of time today, I just wanted to remind everybody that everybody's going to get a copy of these slides for the longer answer so they can read through them. You are going to get an email on that as well. So our next question is, how can a trust be drafted for flexibility in case the beneficiary goes off means tested government benefits?
I like to just have a lot of flexibility. We want to have the trustee having the ability to make any distribution that is in the best interest of the beneficiary. It might still be in the best interest of the beneficiary to hold funds in continuing trust if they go off benefits, which would let the trustee continue to do that. But it might be in their best interest to just outright make the distribution. So giving the trustee a ton of flexibility will let us handle that.
Okay. How can a parent guard against a stingy trustee who refuses distributions in a fully discretionary trust? This is that trust protector that you were talking about, right?
Yes.
Okay.
I've had this happen where my beneficiary really wanted to take a trip. The trust was large. It could definitely have funded the trip that she wanted to take. She was working really hard. She had just gotten out of college. She wanted to take a trip, and the trustee said, no, we're not doing that. And it wasn't reasonable. Them not letting her have a vehicle wasn't reasonable. She needed a vehicle to get around. So having trust protectors who can really look at it and say, I'm going to remove a trustee when they are misbehaving, that can really be beneficial.
So what language should a third-party special needs trust be drafted with to properly set up to receive inherited retirement accounts where the beneficiary gets the lifetime stretch of the required minimum distributions?
This one is a little bit complicated, so I'm going to refer you guys to the longer answers in the slides. But essentially, we are mostly going to want accumulation trusts rather than conduit trusts. So we're going to want a trust that is going to be required to take the RMDs, the required minimum distributions. It must have the eligible designated beneficiary, the EDB, which is the person with the disabilities. It must have the EDB as an identifiable person. It must not have any beneficiaries who are not ascertainable. So for at least the part that is going to be the recipient of these IRA funds or other retirement funds, it can't have heirs at law be our contingent beneficiaries. Our terminal beneficiaries can't be heirs at law because we can't identify the age of the heirs at law. There's a number of other things that you want to look at when doing those, but know that Secure 2.0 has made it harder to do this for people because it's limited the number of people that are now eligible designated beneficiaries. And remember, if you are naming a spouse, you should never put it into a trust.
Okay. All right, for the last 5 minutes, I'm going to go to the chat box and I'm going to read you some questions because the slides that you guys are going to get are going to have the questions and the answers. So I want to get to some of these, as many as we can. Is there a disadvantage of the sole benefit trust? Is that a payback trust?
No. In Texas, sole benefit trusts don't have to be payback trusts. The federal rules don't require it either. Some states do, but Texas doesn't. The benefit is that it allows you to make a gift to your child with disabilities without creating a potential penalty period for the person making the gift. The problem is it requires at least actuarially sound distributions. So if you put $1 million in it and there's a 20-year lifetime, why would I do math? I cannot do in my head. But if we've got a 20-year life expectancy for a person with disabilities, then they must distribute 1/20th of it in the first year and 1/19th in the second year, and so on and so forth. And we may not want to do that in just plain old regular third-party settled special needs trusts. Sometimes we may have years where we make those big distributions, but sometimes we may not, depending on the person's needs. The sole benefit trust does fix a problem for people who might need benefits themselves in the next 5 years, but it creates another potential issue.
Okay, I'm going to read this. This is a long question, and I'm going to have you spout out quick answers and just would say any, if you don't get as full answer as you need, then you can reach out directly to Jen. So disabled adult child lives with parents who are also guardians. DAC is covered by Texas Medicaid, and parent receives monthly payment as a service provider under the HCS waiver. Parent receives Social Security benefits, and DAC has recently been moved from SSI to SSDI. Question 1. What is the procedure for the parent to notify the state of Texas that DAC should not be taken off Medicaid for health insurance? Number 2, will the parent continue to receive monthly payment under the HCS waiver during the period before DAC starts Medicare, and also DAC starts, I think they meant Medicaid and Medicare. I want to answer on one of it. The Health and Human Services, it's supposed to be notified when they switch over from SSI to SSDI to keep Medicaid, but we've been seeing a lot of people get dumped, and you actually have to reapply, and on your application you need to write MEPD DAC Medicaid, and then it kind of goes through and you can kind of push that along. So it's not happening as smoothly as it should, and many people are having to reapply. So that is a thing that could happen. So you want to keep on that. Do you have any other comments on that, Jen?
Just very quickly, you should have to reapply for the waiver program benefits anyway. Make sure you check that you're applying for the waiver programs. I would do it as soon as you know that DAC is going to happen, even before you get that notice from HHSC, because HHSC has been dumping people. If you get the notice that they're dumping somebody, then you want to very quickly file an appeal. If the appeal needs to be filed within 13 days of the date on the notice of the dumping of you, to get continued benefits while that's happening.
And then the other thing is once a kid moves over to DAC benefits or CDB benefits, they're over age 18. After 24 months, they are eligible. They're automatically enrolled into Medicare. You don't have to apply, like it's automatic on how that works. So I wanted to mention that. So our next question, and I think we have time for maybe a couple more. I want to just be conscientious of everybody's time. Anybody that's listened to this on podcast, if you email us, contact@cpgcares.net, we'll send you these slides. How does a third-party special needs trust distribution for food and shelter affect DAC Medicaid?
It depends. DAC Medicaid expressly, that one will still count in-kind support and maintenance. Waiver program, if you've also got the waiver program benefits, the waiver program benefits are going to cover everything that the DAC Medicaid is otherwise covering, and those don't count the in-kind support and maintenance. So for that, if you're getting the waiver program as well as the DAC Medicaid, then you are okay to do the in-kind support and maintenance, but otherwise it will be a countable income.
How does a person know if they're getting DAC Medicaid or waiver Medicaid if they have both? And I've seen situations where they think they have one and it's the other and what have you. And is there one that you prefer over the other? Is it the waiver Medicaid?
Oh, I always want them to have waiver program benefits. The way that you can know this is you should call 211 or, and this is my preference, go to your local Health and Human Services agency to sit down with an actual human being who can look at your case and tell you these are the kinds of benefits that you are getting. Go in with very specific questions about what you're getting. Your Medicaid card should say it as well, but the Medicaid cards can be confusing to read.
Okay, can the trust protector be, I'm going to take just like 3 or 4 more minutes. We're going to just go over anybody that's got to leave. We understand. These are some pretty great questions, and I know you want answers. Can the trust protector be the successor guardian sibling to monitor and help the corporate trustee?
Yes.
Okay. Does the trustee have to live in the U.S.? Our trustee currently lives in Canada. Is that okay?
It's not prohibited, but it is more problematic because the trustee does not have a social security number unless they have a social security number. They are living abroad, but they are U.S. citizens with social security numbers. Having a social security number is an easier way to do it, but it is still possible for them to do.
And one person asked if special needs trust are state or county specific. I know guardianship in the state of Texas is county specific. If you move counties, you need to update your guardianship and stuff like that. But let's say I moved here from California. I live in Texas now. I got my trust set up in California. My trust is still good. I should probably have somebody in Texas look at it and see if there's any other updates that are needed, or what do you suggest on that?
You should have somebody in the state where you're living look at it. While the rules for how these are supposed to work are generally by statute, some of the things tend to be state specific, so it's never a terrible thing to have somebody come and look at it. Generally speaking, you're going to be okay to move a trust from one state to another, but like I said, a sole benefit trust in Texas doesn't require payback provision, but in some states it does. So it's always a good idea to have somebody look at it wherever you're going.
Okay, let's see here. The next question, I have a question about DAC and Medicaid waivers for recipients who also are already receiving SSDI based on their own record. What happens when their parent retires? How do I make sure that getting DAC does not cause my son, who's already getting SSDI on his own work record, lose his waiver? And I guess that also depends if the son is earning more than the substantial gainful amount and whether he's still eligible for disabled adult child benefits under a parent's record or not. And his earnings are going to matter on that, right, Jen?
Yes, so his earnings are going to matter. The income is going to matter. If we've got SSDI and DAC, those are both not means tested for their purposes, but the waiver programs are going to be. If the total of the SSDI and DAC amounts bumps them over the income threshold, though, for the Medicaid programs, the waiver programs, that income threshold can be fixed with a qualified income trust.
Okay. If the DAC has a house owned by the third party special needs trust and money in the first party special needs trust, can the first party special needs trust pay expenses on the house?
Yes, but preferably via the ABLE account. Well, preferably able via an ABLE account if the DAC is receiving DAC Medicaid. If they're receiving waiver program Medicaid, then the self-settled can just pay the rent for the DAC directly to the third party trust.
Someone said, is there a minimum amount needed for basically a corporate trustee such as Bank of Texas? So they have different minimums, and some of them are $1 million, some of them are 500,000. It depends, but few of them are 250,000. So it just depends. Each of them are a little bit different. Let's see. For those individuals who have private health insurance, is there a disadvantage to declining Medicare Parts B and D? No, I can answer that one. I would say, me personally, for my kid, we go ahead, even though we do have group health insurance, we have Medicaid and we have Medicare, we go ahead and take Part B, and Part D personally is what we do. But as long as they're covered by a group health plan, it's credible coverage, so there would not be a late enrollment for Part B and Part D, as long as there's other outside credible coverage. But for us, to me, at the end of the day, when you have the group health insurance, the Part B, the Part A, Part B, Part D, and Medicaid, what that means is we pay for exactly nothing as it relates to healthcare for that kid. So, that's my opinion on that. Let's see here. So we're going to do, let's see, let's see. If a person needs to, let's see. If a parent needs to apply for long-term Medicaid, what is the best strategy to protect Roth IRA funds intended to fund their disabled child's special needs trust upon their death?
Okay, so there's two possible options. One is that they can take the withdrawal and go ahead and put it into a sole benefit trust. The other is they can convert the Roth into what Texas Medicaid called a retirement related annuity, which is just a tax sheltered annuity. This is not a Medicaid compliant annuity. It does not name the state of Texas as the remainder beneficiary. It does not make actuarially sound distributions. This is just a plain old normal tax sheltered annuity on which you can designate the third party trust as the beneficiary. It does not ever have to take distributions, and it is exempt for Medicaid counting purposes for the parent.
Very good. One thing that was in the chat box, and this will be our final thing, I just want to mention, because not everybody knows about HIP, health insurance reimbursement. So basically, you can apply for HIP, and if you are providing a group health insurance for your individual who is getting Medicaid, and that health insurance would actually save Medicaid money, then they will reimburse you for the entire premium for the whole family, not just for that individual. It's a pretty good deal for people. So HIP reimbursement, if you do have your child on the group health plan, you might want to look into HIP reimbursement. And then the other thing, the last thing that I want to mention is the importance of understanding that the group health plan can continue post age 26. So 26 is the magic age. Our kids get kicked off our health insurance. But if we have a kid that has a disability at the start or prior to age 26, they can stay on. Your HR department has a form. They may have never been asked the question before. You might get transferred 15 times. You may have to call the carrier, but your disabled adult child can stay on your group health plan past age 26. So it is important to know that. Anybody on here with the military, there is an application for a helpless child with the military, so you can keep them on the military benefits. And the military age, I don't remember if it's 18 or 21. It's younger than 26. But there is a helpless child application for the military as well. So guys, you guys have submitted wonderful questions. Jen, you've been awesome, and I think that we'll just have to do a part two. Everybody's going to get a copy of today's slides and a link to the recording. We appreciate everybody submitting their questions today and being such awesome participants. And Jen, thank you. Certainly our pleasure. Thank you, Beth, for making the introduction. And Beth is a veteran parent, and she eats, sleeps, and breathes this. She looks at this stuff up one side and down the other. And I know that Beth and I have had a lot of great conversations over the years. So thanks, everyone. I hope everyone has a great day. And thank you again, Jen.
Thank you so much for having me.
Bye now.